So yeah, I'll do this one because this is important. And then I'm going to play some Battlefield 6 Red Sec.
Are you?
Oh. This is Robert. I cannot pronounce his last name. Gavia. Minneapolis ICE shooting case faces Supreme Court reality. Here we go. Here's some evidence that probably, I don't know, but we're going to find out.
Are you going to mention in here that she was obstructing the roadway and that she was ordered out of her vehicle before she accelerated directly into another federal agent? Wow, that's like magic words. I wish I would have known that as a defense attorney. Every client who gets arrested or who is not following lawful orders, all they have to say is, I'm not mad at you. And then cops can't do anything. Gotta let him go. Oh, no. He said it. Stand aside. Let him go. It only asks whether the cop is in danger at the moment of the threat that resulted in the use of deadly force. So forget everything else, just right at that moment when he fired. Renee Good's lawyer now speaking. A lawyer. But she wasn't following agents. And the Good family's now hired their team. And their team has some familiarity here because it's the same team that represented George Floyd. And so here is what they posted in a news release over from Antonio Romanucci. They are announcing that they're launching a civil investigation on behalf of their client, the Good family, and will be calling for peace. Wow. Peace, not only across Minneapolis, a city in shock due to the cruel death at the hands of federal agents on a residential street. All right, here we go. Are you going to mention in here that she was obstructing the roadway and that she was ordered out of her vehicle before she accelerated directly into another federal agent? Blah, blah, blah. Importantly, our legal team is going to conduct our civil investigation so that we have transparency in this case of national importance. And people in Minnesota and Minneapolis truly care about what happened to her. And by the way, these people, I think, got $27 million in the George Floyd settlement. Renee Good's family is now retaining these people. They said, be good. Wow, clever. That is the clear message from her family as Renee's wish to the world. Well, it's not good to run over federal agents. These words also encompass...
So it seems he is obviously biased and on the side of the government who we're watching. I've confirmed it based on that statement right there he just said. He thinks that Renee Good was trying to run over the federal agent. He obviously doesn't know, he might know a lot about the law, but he obviously doesn't know a lot about body language.
It's the mission of their attorneys who have been retained. They're going to be seeking accountability. Now, the legal firm has been around before. They say she was relentlessly hopeful and optimistic, and that was contagious. Had an infinite capacity for love, right? So here, remember, Romanucci and Blandon, they helped secure for the Floyd family $27 million in a civil settlement with the city of...
And he was an actual criminal, bro. Floyd was an actual, like, he was a criminal.
Minneapolis. Crazy, man. So George Floyd was killed, according to the jury, not according to the coroner. He died, according to the coroner, because his heart gave out after he was under arrest. So, of course, Derek Chauvin's going to prison for how long? 20-something years. He's appealing it, and we'll see if that goes anywhere. He's got, I think, petition for post-conviction relief that we looked at here. But the family's now out hiring lawyers. They're looking to get their $30 million from their daughter's death. And the New York Times is saying the lawyer is speaking out, saying that they said that she and her partner weren't following anybody around on that morning. And we're going to get into the allegations here from her defense team, and then we'll compare and contrast it against this case called Barnes versus Felix, which came out from the Supreme Court middle of last year, 2025, a little bit longer than 6 months ago, but decided in May 2025, 9-0 from the Supreme Court. This preceded the case versus Montana Supreme Court decision, which also was 9-0, which says cops can basically shoot you. So here's more from the New York Times article. It says the killing of Miss Good touched off tense protest in Minneapolis. Allies, others immediately defended the federal agent, but for the first week of the shooting, very little was known about this person. Now, Miss Good and her partner, Becca Good, dropped the child they were raising together off at the school in the morning of January 7th. Whose kid was it? They were driving home when they spotted federal agents and stopped. The family's lawyers are now admitting. In cities that have the focus on immigration crackdowns, residents have sometimes shared information about where the agents are. Okay, so they're stalking them. Mr. Romanowski, the former George Floyd team guy, lawyer, declined to say whether the couple had been alerted.
Notice how he said you're stalking them, yet I thought it was our constitutional right to record officers in their duties. And so therefore you have to know where they are going to be able to do that. That is not stalking. Do you see how the lawyer is framing the language. He speaks legalese, bro. Legalese is manipulation on the highest level. I'm breaking it down, bro. I'm done letting these people walk around and spread all this information, and I'm sitting here by myself, bro, and not spreading information. I got information too, and it debunks all these people.
Oh, are they a part of these networks? That immigration and customs enforcement agents might be working on the block where they encountered them, but he said that they weren't following anybody around, right? Videos published since the shooting show Renee Good is partially blocking a residential street. Becca is standing outside the vehicle. Both women speak with an agent who walks around the Honda, and Renee can be heard telling him, "I'm not mad at you." At one point, more agents approach the vehicle and tell
Look how he mocks the dead. You see what I mean? You guys trust these people, bro. Get it? You trust these people. You trust these people, bro.
Tell her to get out. The Honda begins moving. Right into the agent. Jonathan Ross, an ICE agent who's standing at the front of the car, fatally shoots her. Roman Auchi, the lawyer, said he believed the woman had been exercising their right to assemble when they stopped that morning. That right to assemble translated into obstruction, which is a criminal offense, and then it translated into an assault.
Wait a second. I gotta type this for this, okay? He probably won't see it. What was the time? 4:24. Wow. I thought you were a good lawyer. Come to find there is none. You lie just as much as the cops. You manipulate the narrative. ICE does not have the right to detain U.S. citizens for, hold on, let me double check. Can ICE detain protesters for obstruction? Yes, but only under specific conditions. ICE cannot detain protesters simply for protesting. Here's the clean. See, like, look. Cannot. Is protesting considered obstruction or traffic violations? I'm getting ahead of it real quick, so I know what to say when I go back. Protesting itself is neither obstruction nor a traffic violation. Those labels only apply when specific conduct crosses legal lines. Do you see what I'm saying? So look. You guys can't stand, bro. Look, I'm about to freaking give this all to him, bro. Bottom line, protesting is protected free speech and assembly. Obstruction applies only to physical or material interference with lawful duties. Traffic violations apply when protesters block roads or ignore lawful traffic orders. Most protest-related arrests fall under traffic or dispersal laws, not obstruction. So in the case of Renee Good, did the ICE agent have the right to be there or impede her ability to leave the scene. Here's what we actually know from the available reporting and verified sources about whether the ICE agent in the Renee Good case had a lawful right to be there and whether he was justified in impeding her ability to leave the scene. This is not legal advice. This is a neutral summary of public facts and legal context. Exactly. See? Neutral. I trained my chat GPT to be neutral. You see what I'm saying? Did the ICE agent have the right to be there? Key point. Federal immigration agents can operate in public spaces if they are engaged in a lawful federal enforcement operation. In the Minneapolis case, DHS had deployed ICE and other federal agents as part of a large immigration enforcement operation in the Twin Cities. However, the public facts do not show that Good was committing an immigration offense or that she was a target of an ICE enforcement action at that moment, according to multiple reports. Good was a U.S. citizen, not someone suspected of an immigration violation. She appears in video as driving away from the scene when the agent fired. Officials are disputing basic facts, whether she struck the agent, whether she was obstructing, and video is being analyzed. There is no clear, publicly released evidence that Good had committed a crime at that moment of the encounter that would independently justify a federal stop or detention by ICE. Can ICE impede someone from leaving? Under general constitutional principle, a law enforcement officer, including a federal agent, cannot detain or restrict someone's movement unless they have lawful authority to do so. This usually means probable cause to think the person committed a crime or lawful authority to conduct a stop or arrest. Simply ordering someone to leave an area is not by itself lawful authority to physically detain them if they are otherwise free to go. In fact, commentators and some local legal sources note if they are not under arrest, they can be asked a series of questions, yet they can leave. If an agent says you are free to leave, you can leave. The general rule of criminal procedure applies to immigration agents as well. There is no publicly confirmed evidence that the agent had a recognized basis under U.S. law, probable cause of a crime involving Good, to lawfully detain her. What ICE claims happened. Federal officers and DHS have publicly suggested, though it is disputed, that Good was obstructing ICE operations. Yet, saying someone was obstructing is not itself evidence of a crime unless there was actual interference with a lawful duty that amounted to a crime under federal law. That has not been established publicly. What opponents and critics argue, civil liberties advocates and some local leaders have argued that ICE agents were not acting as local police and lacked jurisdiction to enforce non-immigration traffic or protest matters. There was no lawful basis to stop or restrict Good because she was a citizen engaged in a situation involving federal agents, not obvious criminal conduct. These arguments say ICE agents can enforce immigration law anywhere, yet they cannot lawfully detain or impede someone unless there is a legal basis for doing so. What is clear legally? In general, U.S. law, lawful detention or restriction of movement requires one of the following: a warrant, probable cause, a reasonable suspicion to justify a limited investigation stop. Absent one of these, a person is free to leave. There is no verified public evidence so far that the ICE agent had a lawful basis to detain Good or block her from leaving. Bottom line, ICE was lawfully present in Minnesota as part of a federal enforcement operation. Whether the agent had a lawful reason to initiate contact with Good is in dispute, not publicly established. The publicly available facts do not clearly show or a recognized legal authority for ICE to impede her from leaving. Interpretation of the incident is now subject of official investigations and legal scrutiny. This remains a highly active legal investigation situation. I can help explain the standards courts use to judge whether the agent's actions were justified as facts become clearer. And I will get back to that. I'm actually going to lead that. This is gonna be my little thread for that from now on. Let's get back to what homie is saying. He's a lawyer, bro, and look how easily I showed that he's full of shit. Oh yeah, back to this. That's what it is. Can you give me the law that states that ICE does not have the authority that would have justified the officer shooting? Good. See, I already know it was going to bring this up. Copy that. Then I can get rid of this because I don't need that no more. ICE does not have the right to detain U.S. citizens for this. Whoa. This reason alone. Wake up, people. Do your own research. Robert, aren't you supposed to be an expert? AI about to take your job. 'Cause my neutral AI states that you're full of shit. Saying someone is full of shit is the same as saying that he is a liar. And so if I can comment that he is a liar, then I can comment that he is full of shit. Correct?
Placing a federal agent of apprehension of imminent harm and offensive contact, being run over and maybe killed. So Romanowski said that she was.
I don't know. Do you have to comprehend that duality is a full-on mental control? You have a headset on your head that's invisible, bro, that distorts all of reality. That includes sight, hearing, speaking, feeling, all of it. You guys need to wake up, bro. He's in here like he has just hammered home. You know how many times he's repeated like she was she was never viciously trying to run over anyone. You can tell. If you can't see that, you're insane, bro. Well, I mean, both sides, the left and the right, are insane. He's insane. I grew up in insanity. It took me 28 years before I started to asking questions that led me to a place where I am no longer as brainwashed.
exercising her right. This was something that happened very close to where they live. And just like anybody else who lives in the neighborhood, if there's activity going on, they're going to be asking what's going on. They're free to do that. They can call their friends, text message, stand on their front porch and look around. They can't run into the middle of the street to prevent their movements and obstruct their efforts. So the office said Renee
I can't help it, bro. 4:48. Where did anyone run into the street?
Good and Becca Good, both U.S. citizens, moved to Minneapolis in March. They were becoming more involved in their city. Great. They thought that Minneapolis would be a better place for their blended family. Yeah. The couple were raising children together, a spokesperson for the law office.
Ooh, the apathy coming off of his voice.
Also said that she
comprehend, I'm neutral. I don't care about either side's feelings. I comprehend that Renee was breaking the law in a traffic violation type of manner, not in the get killed by an ICE agent. ICE agent didn't have the authority to be there, even attempting to detain her for blocking traffic. The fact that no one is talking about this, no one. This is like the third or fourth lawyer I've watched talking about this situation, and none of them have brought up the procedures and laws that the ICE agent must follow and their authorities and duties while inside the United States.
had just applied for and become approved to be a substitute teacher. Declined to say whether she had joined a neighborhood group chat, so probably did. Did she track agents? Probably. Did she attend any training sessions about watching ICE? Probably. Didn't want to ask about that or answer that. Did she observe any immigration agents that morning of the shooting? But he did say that they were engaged with their neighbors about this activity and they were concerned about it. So he said that we're opening up a civil investigation. He and another lawyer sent federal agents and officials in a letter saying, preserve your evidence. The letter said the family anticipated legal action against the United States and the agent who fired the shots, of course. Romanowski said the family's options included a tort claim against the government and that it could be a...
You gotta think, there was someone that came out that tried to say that someone distorted what the father said about his own daughter and tried to say that he agreed that the shooting was justified. So people are out here lying both sides, bro, heavily, attempting to manipulate you. One is here to attempt to alleviate the pressure on your brain. I don't care what you think of me. I don't want you to trust me. Go do your own research, start asking more questions, answer those questions, and then question those answers to see if they fit the actual question you're asking. Because just because you ask a question doesn't mean you're going to get the correct answer. Because what if you're not asking the right question, the correct question? Do you see what I'm saying? And so until you learn and figure out what questions are correct to ask, and then you will never figure out how to get the right answer. Do you see how you are in a full of shit, spaghetti brain masterpiece of dysfunction?
Difficult and challenging path given Supreme Court precedent. That's not going to be easy for them at all. Federal officials have repeatedly defended the agent's actions as lawful and necessary. When someone tells you, I'm not mad at you, you don't raise the temperature from 0 to 100 just because you don't want them there. Like, wow, that's like magic words. I wish I would have known that as a defense attorney. Every client who gets arrested or who is not following lawful orders, all they have to say is, I'm not mad at you. And then cops can't do anything. Gotta let him go. Oh, no. He said it. Stand aside.
They are not cops, or they are. They're federal agents. They're not cops, bro. Do you see how he's confusing and conflating language? They're not cops. Cops are local police officer. That's cops. That's what everyone knows is cops. He knows it. I know it. Everyone knows it. He's a fucking liar, and I'm so sick of this, bro. It's very infuriating, bro. I'm awake now, bro. You got me awake now, bro.
Let him go. Suffering greatly, so they're all saying the family's extremely hurt. I have no doubt about that. I mean, it's tragic. It's really something that shouldn't have happened. The FBI is investigating the shooting on its own and has resisted calls from the local people who are all... We know how the local forces handle this. Watch what happened to Derek Chauvin. They convicted that dude 100 times over, 1,000 times over in the media before he even stepped foot in trial. And he had jurors in the panel who attended George George Floyd protests and are on videos in hoodies saying, "Get your knees off our necks." That guy gets on the jury. Fair and impartial jury of your peers. Right. So, of course, they're going to try everything they can to drag this case back into their jurisdiction, but he's a federal agent, whole different ballgame for them. And one case that has been referenced often that is not good for them is this one, Barnes versus Felix from the Supreme Court, coming up out of the Fifth Circuit. This was decided last year, May 15, 2025, and it's about an agent who shot someone and killed them in a car. Respondent Roberto Felix Jr. is a law enforcement officer, so Felix is the cop. Pulled over this guy called Ashton Barnes for suspected toll violations. Felix ordered Barnes to get out of the vehicle. Okay, a toll violation. Get out of the car. But Barnes drove away. As the car began to move forward, Felix, the cop, jumped onto its door sill and fired 2 shots inside the vehicle. Barnes was hit, but then stopped the car. 5 seconds elapsed when the car started moving, and when it stopped, 2 seconds passed between the moment that Felix stepped on the door sill and the moment he fired the first shot. Hops on the side of the car. He's not even in the front of the car. Hops on the side, blasts through the window, dude's dead. 5 seconds later. So Barnes' mother sued Felix on Barnes' behalf, saying that Felix, the cop, violated his Fourth Amendment right. This is excessive force. You can't just show up and shoot somebody. The district court granted summary judgment for the cop. Said, no, there's this concept called moment of threat rule, that at the very instant, okay, so you have this thing that happened over 10 minutes, but what happened within like that 5 seconds before he pulled the trigger? So we're going to just zoom in like a microscope. Moment of threat. The Court of Appeals said, yeah, that's a great rule. It only asks whether the cop is in danger at the moment of the threat that resulted in the use of deadly force. So forget everything else, just right at that moment when he fired. Now, under that rule, the events leading up to the shooting are not relevant. Here.
Wow. So the cop put himself in danger by being in front of her car, and then, he felt threatened, he can kill her. So basically, the agents can put themselves in danger and then justify killing you for them putting themselves in danger. Because there was no reason for him to be there. Again, I told you, if you watch the video, they had the ability to go around her. The cop that actually walks around and ends up killing her was parked behind her, and she was in the lane like this. He drove around her and then pulled up and pulled his car into the lane just like her car was into the lane. So he blocked traffic just like she blocked traffic, and then the truck pulls up behind them and blocks her in. So they did a block in maneuver to stop her from blocking traffic when they don't have the right to detain her for traffic manners.
The precise moment of the threat was relevant. Doesn't matter if it was toll violation or any of those things. It was the 2 seconds when the cop was clinging to a moving car, right? And the fact that the cop didn't have to cling to the moving car didn't matter, according to their analysis. Okay, so in other words, did he approach and try to seek the danger and then create an environment that caused him to shoot this person? Because Felix could then have reason to believe his life was in danger right at that moment, the panel said the shooting was lawful. So that was the original rule. So the Supreme Court came back in May. They said a claim that a law enforcement officer used excessive force, which required this shooting, is analyzed under the Fourth Amendment, and it has to be objectively reasonable from the perspective of a reasonable officer at the scene. Now, the inquiry into the reasonableness, so was the cop actually acting reasonably? And it's not subjective. It's not, did this cop think he was acting reasonably? Because all cops are going to think, of course I was at the time. An objective officer, if you took this cop out and you put another cop in, would we all say, yeah, that was reasonable? And then take him out, put someone else in. Yep, that's reasonable. So it's objectively, it's not based on the subjective interpretation of the cop at the time. The inquiry into the reasonableness is based, though, not on moment of threat. Now it's based on totality of circumstances. So the Supreme Court is actually zooming out on this, saying, well, you have to analyze everything. Yeah, did he hop on the side? Did he, what was going on before? What was going on after? You can't just zoom in on that exact second. Now, the analysis demands careful attention to the facts and circumstances related to the incident. And most notable here, the totality of the circumstances inquiry has no time limit. It's not just 2 minutes. While the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood this and responded. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. In fact, another Supreme Court case already illustrated this. In a prior case called Plumhoff, the officer's use of a deadly force was justified at the moment, partly because of what happened before that moment. Now, what happened here in this case, the Supreme Court said, is that the lower courts applied a rule that that prevents that attention to context. You have to really zoom out on the whole thing. And
Right,
thus it
exactly.
conflicts with what we've said before, that you have to analyze things with the totality of the circumstances. But by limiting the court to just 2 seconds before the shooting, the lower courts could not take into account anything that preceded that final moment. So for example, they couldn't even consider the reasons for the stop or the earlier interactions. And because of that limit, they could not address whether the final 2 seconds of the encounter would have happened differently if you would have analyzed it within the longer time frame.
Right.
And so
That
a
makes-
rule like
that
that,
makes all-
that
the only
precludes
sense.
all of the prior events is not reconcilable with the fact-dependent, context-sensitive approach that we've told you to do previously. And so a court that is deciding a use of force case has to review the totality of the circumstances. This court does not address a separate question about whether or how an officer's own creation of the dangerous situation factors into the reasonableness analysis. The courts below never confronted that, and it was not the basis of a petition for cert. So if the cop came to the scene, right, created it, they're not really considering that right now. But this cop, in the totality, they say needs to be analyzed. So what they do is they send this back. Kagan delivered the opinion for a unanimous court. So everybody agreed on this. That's the rule. So they sent it back down to the Fifth Circuit. Then the Fifth Circuit got the case, and here is what they said in response. Now they write, all right, listen, a lot of things changed. We've got advances of the genre of Morse code. With its 26 letters and 10 numerals, railroads and flight challenge the social order and perforce its legal regime. Today, we repair to the horseless carriage with its, good gosh, so much prose. From a unanimous Supreme Court came
Right.
pretextual stops. Yeah. Enabling police officers to stop an automobile upon probable cause that any traffic violation has occurred. It's true. They can even stop you even if the stop is in search of another violation. Now, even before that, the Supreme Court, aware of the inordinate risk confronting officers, even granted officers to order people out of the vehicle. The import of these decisions cannot be understated, as traffic stops are among the most common interactions the public has with the police. And so we've had these
Again, he's not pointing out that ICE is not police. ICE is not local officers and enforcement. They have no authority to do traffic stops.
common sense protections, and it enables officers to distance the driver from weapons or contrabands, right? Order them out of the vehicle. The vehicle can be dangerous. Other things in the vehicle can be dangerous. Supreme Court has said you can order people out. It prevents a high-speed car chase. It prevents a fleeing felon. So we've enabled this. So the officer's power to preempt flight by separating the suspect from his vehicle is crucial as a driver who speeds away can become a danger, a significant danger to both the officer and the surrounding community. And so it follows that the choice to use deadly force in that situation is presumptively reasonable when the officer has reason to believe that the suspect poses
I think he's using another case study.
a threat of serious harm to the officers or others. Now, this well-settled precedent dictates the outcome of this case. Here, the deputy, Cop Felix, fatally shot Barnes on the tollway. Barnes' parents sued. Lower court gave summary judgment on the plaintiff's claims against Felix and their claims against Harris County. And so, bound by this decision, we affirm. Now, under that doctrine, the excessive force inquiry is confined to whether the officer was in danger at the moment of the shooting. Now, while the 5th, 2nd, 4th, and 8th circuits have applied this truncated analysis, the majority of our sister circuits, under the totality, would determine the reasonableness of deadly force. Now, a concurring judge on this panel urged the Supreme Court to resolve this circuit split. That's what we're doing now. And it did. In a unanimous decision, the Supreme Court reversed our moment of threat rule. The court found that Tennessee versus Garner and its progeny control. They said you have to use the totality of the circumstances. Now, 4 justices, okay, so it's kind of like they have different rationale for it. They concurred in a separate writing of Justice Kavanaugh, and he emphasized the weight of the courts should be the suspect's flight, however innocuous the initial reason for the stop may be. Kavanaugh said there's inherent dangers in traffic stops, tactical disadvantages. You don't know what's going on. There's unpredictable threats. There's no easy or risk-free answers. Cops have to protect themselves. Letting the driver go endangers the surrounding community. It degrades respect to those who are due it by their virtue of serving and protecting. Intervention is even more dangerous, whether by giving chase, shooting out the driver's tires, jumping onto the vehicle. And so you have to do the totality of the circumstances. What if they evade by flight? So here, our analysis now of the cops' qualified immunity defense must appreciate all of those other things. Extraordinary danger and risks facing police officers when the driver has suddenly pulled away. So on remand, and with the power of this, most moment of threat doctrine's temporal strictures lift away, we review de novo, fresh, whether summary judgment is proper in light of the totality of the circumstances leading to Barnes' death, and we affirm. Now, to establish that this was a violation, the court considers the totality of the circumstances, flight risk, and all of those things. But when an officer does invoke qualified immunity, the burden shifts to them to show why the cop was actually wrong. Qualified immunity gives the benefit back to the government. Now, the facts giving rise to the plaintiff's claims unfolded in under 2 minutes. Felix stopped this person on a tollway. Radio broadcast around 2:40 said, well, outstanding toll violations. This guy's just traveling back and forth. So the cop located and stopped the Corolla on the freeway. A reasonable decision given his probable cause to believe that a misdemeanor traffic violation had occurred. The dash cam footage shows that the taillights
like, I know he's going to try to use this to defend the ICE agent, but I don't know how he doesn't get that the ICE agent isn't a beat cop, bro.
Extinguish while the left blinker remains on, indicating that the driver turned the engine off but kept the keys in the ignition. Then the cop exited the vehicle, approached the car, said, I want proof of insurance, driver's license, registration. The driver, Ashton, told the cop, don't have a license. Car was rented in my girlfriend's name. Then he began to reach around the floorboard and rummage through his papers. Cop then claimed that Barnes maintained eye contact with him as he did so, and Barnes stopped after Felix repeatedly told him to stop digging around. Cop also smelled marijuana and asked for Barnes if anything else in the car he should know about, called for backup. Barnes then claimed his identification was in the trunk and opened it for Felix to go get it himself, the cop. Barnes then placed his keys near the gear shift and the blinker turned off. Then at 2:45, exercising his right to self-protection, Felix ordered Barnes to exit the vehicle and placed his right hand on the holster as the door opened. Ignoring the order, Barnes grabbed his keys, started the engine, began to drive away. Now, understandably, the cop recognized his conduct as an attempt to flee. Felix said something, the cop, to the effect of, don't do it. In that moment, all that a reasonable officer could have concluded was that Barnes was intent on flight, and if he were allowed to do so, he would then be a deadly threat to others on the road. The vehicle would enter traffic in the fast lane of the freeway, because the very fact that a suspect flees when suspected of a minor offense could be well indicative of a larger danger. So Felix, the cop, faced a split-second decision, had only bad options. Had he remained flat-footed on the pavement, Barnes could have started a perilous high-speed chase during rush hour on Houston's busiest toll road. Even if he did not speed away, he could have seriously injured Felix with the car. So if Felix had stepped onto the car, he could at least hang on and command Barnes to stop. So cop mounted the door sill with one foot, placed his body partially inside the car. As the vehicle accelerated, Felix stepped on it with both feet and yelled, don't effing move, twice. In the little time Felix had to act, and with little he knew about Barnes, Felix did not act unreasonably in protecting himself and others. Instead, the cop, having spent 11 years on the job with an advanced peace officer license, did exactly what he was trained to do. As the cop clung to the door frame of the accelerating car, he withdrew, then reinserted his weapon into the passenger compartment towards the driver's seat. Barnes kept driving, so Felix shot inside the vehicle, acting reasonably and using deadly force to end the risk of flight. And because Barnes did not stop, he acted reasonably in firing a second shot. Felix continued to hold Barnes at gunpoint until backup arrived, and Barnes was pronounced dead at the scene, 2:57. Based on undisputed testimony and events depicted in video and the cop's uncontested testimony, we find, based on the totality of the circumstances, that no genuine dispute of material fact exists as to whether Felix used excessive force in an objectively unreasonable manner at the time of the stop. And because the plaintiffs, the family, have failed to satisfy that first step, raising a dispute of material fact, we don't reach anything else about whether his rights were...
So see, he's using something where, dude, you can use any case, dude. He could use 5 cases where it shows that it wasn't justified, but he chooses to use one that states that it's justified, and he's not stating that ICE doesn't have the authority for local traffic violations, bro. Not even obstruction.
Violated. And so accordingly, the plaintiffs have failed to meet their burden to defeat this invocation of qualified immunity. They lose on
Sad. It's sad, really, bro. You're sad, bro. I thought you were cool. I thought you knew what. I thought you were like, no, you're just another bullshit lawyer, dude, that lies.
Excessive force and deadly force claims against him. Felix is entitled to summary judgment. He wins by default at this early stage. And as the plaintiffs have failed to show a constitutional violation, summary...
See how he ends the video? I'm not even going to listen to the rest of that. See how he ended the video with saying that the cop was justified for Renee Good because he's using this as the example. And the example is shit because it has to do with an actual legit traffic stop and an actual local police officer, not an ICE agent. ICE agents aren't aren't local police. They don't have no authority to give you a traffic ticket or detain you or any of that, bro.